Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome back, everyone, to the Aitken Robertson YouTube channel. And today I'm joined again by counsel Phil Stiles, and we'll be discussing internet crimes and the defenses, the common defenses that we have. So, Phil, internet crimes are extremely serious, but there are some legal defenses available in some cases. Can you give us an overview of some of these key defenses?
Certainly. Well, just an example of one that really it hinges on the way that file sharing works online is the defense that you simply don't have the knowledge that something is being uploaded or downloaded. So just by way of example, a lot of file sharing programs, typical to back in the day, we used to have Napster or LimeWire, that kind of file sharing network, peer-to-peer, they call it peer-to-peer file sharing. You can actually not have any knowledge at all of what has been uploaded or downloaded to your computer and what is being uploaded by other people. The analogy of kind of leaving your kitchen door open at the back of your house and being up in your room and people just kind of coming in and putting ingredients in and taking ingredients out. That analogy has often been used to describe how these file sharing networks work, because you can click on a large file, not knowing all of the contents, walk away from your computer while it's downloading, and even before the entire file has stopped downloading, you can have people uploading things from that particular file. So in other words, you haven't even opened the file, you're not even looking at anything, but somebody is already taking it from you, and you can run into charges that involve an allegation that you distributed something because somebody else got something from you. So basic knowledge can often be used as a defense, or a lack of knowledge that you had any illicit material on your computer. Another very popular one, or common one, I should say, are charter violations. If there was a charter violation in, for example, the execution of a warrant, the ITO, or information to obtain, wasn't done properly, if there was any issue that would make the warrant invalid, then all the chips fall, usually for the Crown. Everything seized pursuant to the warrant can no longer be used in evidence. So that's another example. So there's a whole range of defenses that we tend to use, and a lot of them are unique to the way that programs work on your computer, and that IP addresses are assigned, and they're unique to the complexities of the computer system and the networks that you're using. So anyway, lots of defenses.
What role does shared access, where there's multiple people using the same login credentials, play in as a defense?
Well, that's actually another defense, really, is if you have, I mean, we call it the identity defense, meaning that the Crown has to prove beyond a reasonable doubt that you were the person at the computer or using the device that did the illicit thing that is alleged, right? So if you have multiple users on a computer, each having access to the computer with the same password, then it can be very difficult for the Crown to prove the identity of who was clicking the mouse at the time. Even more difficult for the Crown is if there's a Wi-Fi network that is not password protected. Many people forget to put a password on their Wi-Fi, and all that needs to be shown by the defense is that anybody could have come and used the Wi-Fi network, and that whatever illicit activity is associated with that IP address could have been the work of 100 people. So you have to look at who's using the computer, how many people in the house are the residents, and who has access to what. They're all relevant questions when it comes to defending these types of cases.
But what should someone do if they find themselves being accused of an offense like this?
Well, there's not a lot that can be done initially. You can't, you don't want to be obstructionist. You don't want to hide evidence. You don't want to do anything like that. My advice is to get counsel immediately and explain your situation preemptively, even before charges are laid. If you think there's going to be a problem, you need the advice of a lawyer right away.
Thank you so much, Phil, for joining us today and for giving us a little bit of insight into internet crimes. And thank you to everyone else for joining us on the Aitken Robertson Legally Speaking YouTube channel. So don't forget to like, subscribe, and hit that notification bell. Until next time, stay informed, stay engaged, and take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.